I am here today with our general counsel, Dana Remus, and I'm going to make a few opening remarks and then we'll take your questions. The purpose of the briefing today is to put in perspective some of what you're reading and hearing about, which is noise, not really law, theatrics, not really lawsuits. And I want to focus on a few very specific issues. Number one, why these Trump lawsuits are failing around the country and will continue to fail. I want to pick out a couple of specific issues in the legal process that you should be familiar with, any upcoming recounts and what they might mean, and particular arguments that you're hearing from the Republicans, certainly fraud, most notably, but also supposedly linked to this argument about fraud, the exclusion of observers from polling places. And then I'll say a bit about the state legislative activity that you may be hearing about, where I think there are also some significant misconceptions. And when I'm done, I think you're going to find out very quickly, or you're going to understand very quickly where the real fraud in this process actually lies. But let me begin by talking a little bit about the lawsuits to date, just to give you an overall perspective, since you're reading that they're being filed, but the disposition isn't always very clear. Through Election Day, from June through Election Day, judges have dismissed Trump campaign lawsuits in this election, against this election, as utterly unsupported by evidence. That's just from June through Election Day. 6 suits dismissed on that basis. Since Election Day, the pace has picked up, and judges have dismissed another 7 cases that the Trump campaign brought in these states: Georgia, Michigan, Nevada, and Pennsylvania. So that's quite the one-loss record, losing time after time. Now, I want to just go through a few of these to give you a flavor for what we're talking about. Let's take, for example, 6 months ago, to go in the pre-election period and talk about a Trump campaign effort to limit the ability of voters to vote by mail, including by drop boxes. And there, the Republicans made their usual argument that these drop boxes, the use of these drop boxes, would lead to fraud. The judge who heard the case, by the way, was a Trump appointee, and he invited the campaign to come forward with evidence. Of course, there was no such evidence. And I say, of course, because you'll see it as a theme that runs throughout all these cases. And he threw the case out, saying that the contentions, the fraud-related contentions that the Trump campaign made, were purely speculative and unsupported by the evidence. This is a case, by the way, captioned very specifically, Donald J. Trump versus Bokvar. So this is a Trump campaign lawsuit. Another lawsuit in New Jersey that had to do with ballots cast after Election Day, as provided for by the state legislature. There too, the judge threw it out, finding no evidence whatsoever that the mail-in balloting program adopted by New Jersey would lead to election fraud, including specifically no evidence that the voter fraud would result from ballots that were cast after Election Day, that there were such voter fraud resulting from votes cast after Election Day. The Trump campaign sued the Montana vote-by-mail system. And again, a federal court threw out the suit. And here, I think the rhetoric, or shall we say the measured comments of the court, deserve quotation. The court explained that it was required to throw the suit out because the Trump campaign's, quote, contention that the upcoming election, both nationally and in Montana, will fall prey to widespread fraud is a fiction. So the court dismissed it as a fiction. And again, this is a Trump campaign lawsuit, not a party lawsuit. Donald J. Trump for president versus Bullock. And then the Trump campaign filed a lawsuit attacking expanded vote by mail in the state of Nevada. Here too, we have a judge appointed in this instance by George W. Bush. He threw out the case also because there was no evidence, only speculative, far-fetched claims about fraud. Once again, a case brought in the name of Donald Trump's campaign committee. So what you have is one case after another, and this is just a sample, where the claims that they're bringing, amplified through press releases, including the fabled Four Seasons landscaping company press conference by Rudy Giuliani, turns out to be completely meritless, and the courts recognize it as such. In fact, and I just want to focus everybody on what the Trump campaign says when they actually speak to a judge versus what they say in parking lots at press conferences. In a case in Montgomery County in Pennsylvania, this case involved, by the way, the question of whether or not a ballot would be invalidated for missing a signature in a particular location or an address in a particular location, even though the voter's address was readily identifiable elsewhere. And the Trump lawyers were actually pressed on the question of whether they were alleging fraud. And so I just simply want to give you the following from the transcript, because this is what's taking place inside the courthouse and not in the parking lot. Judge, in your petition, you don't claim any of the voters committed any fraud, correct? Trump lawyer, accusing someone of fraud is a pretty big step. We just want to get the election done. Trump judge, I understand, but I asked you a specific question and I'm looking for a specific answer. Are you claiming fraud? Trump lawyer, to our knowledge at present, no. Judge, are you claiming any influence? Trump lawyer, to our knowledge at present, no. Judge, is that required to lodge that challenge? Do you have to accompany your complaint with an allegation of fraud? Trump lawyer, no, it doesn't matter if there was fraud. It doesn't matter if the mistake is a big deal or not. So I think that's fairly telling. Very different than what you're hearing, of course, in the parking lot. Now let's move to the question that you've heard come up repeatedly about observers and lack of transparency because observers were excluded or limited in their access to the vote count in polling places. Let's be clear. Poll watchers are credentialed, they're identified to the state. It is very easy to fact check this claim. And of course, these claims have been repeatedly fact checked. The Republicans, after all, before the election were bragging that they had thousands and thousands of poll watchers ready to go. And it was only after the election on this sham allegation about transparency that they claimed their poll watchers were not permitted to be included. As a matter of fact, they were there in force in the same way Democratic appointed poll watchers were to do what poll watchers are allowed to do under the election code. And again, in front of a judge, rather than in the parking lot, Trump lawyers have admitted in cases that had to be dismissed because of that admission, that indeed they had poll watchers present. That was true in cases in Pennsylvania and also in Michigan. As you know, and Kate mentioned this a minute ago, the two current senators in Georgia, unhappy about the runoffs they were forced into, complained that the Secretary of State had not conducted a transparent process. And you can read what his response to that was. Republicans attacking Republicans on this bogus claim of lack of observer access. Simply untrue and easily verified on the facts. Two final comments. Many of you are aware that there may be recounts. Let's talk about what it means for there to be a recount. One fact and one fact alone, I think, might answer any question that you have. Since 2000, in 31 statewide recounts, the average change in votes was 430, and the median change was 267. End of story. These margins cannot be overcome in recounts. So the recounts are yet another piece of the political theatrics, along with the lawsuits being dismissed with their claims of fraud. They shouldn't be taken to be a serious challenge to the outcome of the election, and they will fail as such. Finally, my last comment before we take your questions has to do with activity in the state legislatures. Some people are under the impression that a state legislature can not only hold hearings, which it certainly can do, and complain, which it certainly can do, but the state legislature, after providing for electors to be selected by the popular vote, can, after the election, decide that wasn't the way they should have gone. And on whatever ground they give, they have the constitutional right, after the fact, retroactively, to pick electors who are committed to the candidates who didn't win the election with the voters. That's simply not true. That's not in the Constitution. That's not consistent with the Constitution, and that will never happen. But I want to be clear that that's another bit of, call it what you will, puffery, propaganda that's being put out on the Trump side. Again, it is very easy to establish that it isn't true.